Welcome to Rebel Chaser. My name is Gail, and we've got another Judge Middleton. This time it's a man named Tom Middleton from Grant County, Washington Superior Court. And he has got one big mess to figure out. I'll let you guys watch.
All right, Mr. Castillo, if you'd go ahead and put your credentials on the record.
Of course, Your Honor, for the record, assisting with this matter, certified court interpreter in the Spanish language, number 108. Okay.
All right. There were some materials filed in the 3 case just today, but it's for a hearing that's in a couple weeks, right?
Child support hearing, Your Honor.
Yeah, and none of that is being considered for today, correct?
There's nothing salient today in those materials.
Just wanted to be clear for the record because I saw stuff was filed today.
Yeah.
I haven't reviewed it, but it did appear to be financial, for a hearing noted in a couple weeks.
Yeah.
So
I would just, Your Honor, I would just ask that the materials from this hearing, if the court could hold those over, because I noticed the bench copies I brought up this morning did not have the sealed source financial documents and some stuff in them. If we could just mark, for the hearing on the 21st, the packet that you have here
I'll keep
today, and then put it with the new ones, then it'd save some paper and confusion, so.
Sure. No, I'd keep all of them until we're kind of done with the temporary orders, and then I
Well,
can get rid of all of it.
Okay, that's a good idea, yes.
All right. Any preliminary issues, Mr. Huberto?
Nothing from me, no, Your Honor.
Mr. McGee?
No, I don't have anything preliminarily, thank you.
Okay. And I think Mr. McGee's the moving party in the 2 case, and Mr. Huberto's the moving party in the 3 case. But I'll just hear probably from both of you, give each a time or two to go back and forth, make sure you have an adequate opportunity to present your case, and then the court will rule. So,
I'll defer to Mr. McGee if you'd like to start, or if he doesn't, I can do it as well, whatever he prefers, or if the court doesn't have a preference.
I don't. I would like to. I know you can kind of separate it a little bit, but because everything flows together on these as far as the DV protection order and the parenting plan, just give me your everything and I'll rule.
Yeah,
So,
sounds
Mr.
good.
McGee, you can go
Yeah,
first.
I can go. Your Honor, it's not often that I receive a declaration that seems so full of dismissive hubris as I did when I received Mr. Curiel's declaration. This declaration goes on, she's just mad at me because I found another woman, and there's nothing wrong, and it's just this belittling, dismissive diatribe against the mother of these children. And this is an interesting situation, because my understanding is that Mr. Curiel has been allowed to live with my client's mother. And because of his lack of moxie in life. And notwithstanding that, when my client, Ms. Garcia, goes over to check up on her mom and the situation and discuss some things that have come up with the kids involving an assault by Mr. Curiel's girlfriend, flavor of the month, whatever she is, on one of the kids, he attacks her. He grabs her by the hair, her up against the wall, pull my hair and push me. I was telling him to stop. He was hurting me. He wouldn't stop. He then got me out of the room, and my mom told him to stop. So you have a physical assault. I mean, assaulting someone's daughter in that mother's home is just, it's kind of beyond, who's providing a place for him to stay because of his lack of drive and moxie in life is really disturbing to me. And there's an additional incident that happened in October 2024, which kind of speaks to the bizarreness and immaturity of this dad. You know, they're at the pumpkin patch in October 24, which is a kids event. You know, they're trying to get along, and you know, he loses his cool, starts calling her fat and ugly, you know, in public in front of other people. I told him to stop. He said no. Again, this inability to control himself, this impulse control behavior. He then grabbed my hand and put my finger in his mouth, and my finger, and it started to bleed. So, you know, we have two significant impulse control issues with this gentleman with respect to the mother of his kids, with respect to Ms. Garcia. And, you know, there's really not much of a very satisfactory explanation about, you know, well, it was just a mistake, or, you know, I was trying to trim her fingernails for her or something. I mean, he's biting her, pulling her hair, and in front of other people and in public places. And, you know, my client's mother, you know, verifies that this assault happened in her home. So certainly there needs to be a DVPO order issued in this case. It just, without a doubt. Now that leads into the 191 factors. You know, the client should have sole decision-making. The father's time with the children should be limited based upon the assaultive conduct, not once, not just, you know, but twice in recent history that is specifically cited here. And basically, you know, everybody has been trying to help Mr. Curiel. I mean, he's an alcoholic, has an alcohol problem. And, you know, Mr. Salvador Lazo Curiel is an alcoholic. Every day when he would return from work, he would drink up to 12-pack of beer. He would be drunk around our children. Often, on several times, he would get so drunk that he would throw up and even pass out in front of the children. And then there's a very disturbing increase in drug use. You know, I also found what I believe to be in his belongings, once on October 10th and again on December 24th. Now, we could only hope that it is cocaine. Probably, given modern times, it's probably meth. But even worse. Okay, from bad to worse. So we have the lifestyle of this, you know, kind of in and out, that's reflective of this sort of substance abuse, use of drugs, use of alcohol. You know, he is not a man with moxie, with forward momentum, going anywhere in life. So I think at this point, and this is a temporary parenting plan, that it is our parenting, that it is Ms. Castillo's parenting plan that really is the wise choice for these kids. And, you know, the kids are fairly young, you know, 5 and 3. And these are the kind of kids that aren't really able to self-advocate, aren't really well able to self-report. And given that issue, we think our parenting plan, well, we're sure that our parenting plan is really the only wise and best choice. If these kids were 13 and 15, 17, 12, 14, maybe a little different story. But given the youthfulness of these kids, I mean, a 12 or 14-year-old can ride his bike over to mom's house when dad passes out drunk. You know, a 3-year-old and a 5-year-old, much more vulnerable. So I would, you know, you have real concrete events problems verified by 2 people. And in response to that, we kind of get a sing-songy, oh, she's just mad because I decided to chase other women, dismissing her concerns about his behavior. And that's really the substance of the case. There are significant problems with Salvador, with Mr. Curiel. Now, the parenting plan that we've proposed, very briefly, does not provide for contact at the present time. And it does provide for, it provides, I believe, for him to get some treatment and evaluations to figure out where he's at. And if he doesn't have a problem, then he shouldn't be objecting to that because it's going to come up with no problem. And now, when those are in, when those evaluations and reviews are in, then of course the court, and if he's complying with any treatments recommended, the court can take another look at this and decide if maybe there's a better plan, if he's in treatment, dealing with his anger issues, dealing with his domestic violence, dealing with his substance abuse issues, then at that time the court can take a look to see what is, if there's any supervised time that's available, or maybe he makes such great progress with his problems that the court says, hey, an overnight now and again is appropriate. But at the present time, for the safety of the kids, given impulse control problems, which are fueled partly personality and then partly very likely substance abuse related, parenting plan provided by Ms. Garcia is really the safest one. And his involvement with the kids, kind of in and out, and not much contact, off and on. It reflects problems of the type that are described by Ms. Garcia. So if he's going to have any time, he hasn't had much time for a long time, has not been involved with these kids, mostly out chasing other women. Any reentry of the kids into his life needs to be on a very graduated scale, and with some monitoring at this point, some monitored contact. However, we think that the problems are escalating, becoming more severe, like as exemplified by the attack, that at this point, until the court can figure out what's wrong with this gentleman, or get some idea what's wrong with him by way of some testing and some evaluations, that there should not really be any, in-person contact, just phone contact. Your Honor, unless there's any questions, that's all I have. It's just have to point out that, it isn't just Ms. Garcia coming forward and saying this. There are other people that are verifying this in the declarations that are brought before the court. He is not this is not Mr. Huxtable dad, involved with these kids. He is at best a shadow that occasionally passes through their life in between chasing his women and his substance abuse problems and his impulse control problems. I guess those are all kind of impulse control problems: women, drugs, booze. But maybe if we can clean him up a little bit, he can be an adequate dad and some point in time have every other weekend. But that's not today. Thank you, Your Honor.
The only question I had right now, and I'll hear from Mr. Hubert, I'll have a question or two afterwards, was you said that there were corroborations of a couple incidents? Unless I missed something, which I could have, because there was a lot of different declarations describing different things. I saw your client's relatives supply declarations about the December 8th incident at the mom's house, at grandma's house. But I didn't see any other specific corroboration of a specific allegation made by mom in her declarations in either the 2 or the 3 case.
Yeah.
Like I said, I do acknowledge there's, again, some generalized, he's a bad guy, he drinks a lot. But as far as specific allegations, was there something besides, like the pumpkin patch one? I didn't see any corroboration of that anywhere, but I could have missed it. But I did see corroborations of the alleged December 8th incident from the relatives. That's applied.
Well,
but you said a couple of corroborations.
Well,
is that accurate, or was that just?
I think I misspoke.
Okay, that's fine.
There's multiple corroborations of the December 8th event. You have the Cassandra Del Wareham.
No, I saw that.
She witnessed his
I
impulse
understand.
control. Yeah, and then you have the Maria Morrow that corroborates that. But I don't have a pumpkin patch.
No other events, just the December.
I don't have someone that saw him bite her finger or hand. At least I don't have a declaration from somebody that actually witnessed that. But I got plenty on December 8th and then some.
Mr. Huberto?
Thank you, Your Honor. Those were questions I was going to bring up as well. So something like this, where it's, and sadly we see it all too often. It's he said, she said, with very little, if any, collaboration, which I'm going to get to in more detail here in a moment. But so I always try to start off with what is it that we know or the agreed facts, right? What are the things that neither party can put their own personal spin on or have chosen not to put their own personal subjective spin on it? Well, there are very few in this case. we have a situation that's clear. These parties were married. They're now going through a divorce. Regardless of whether mom wants it or not, they're going through a divorce. They were married in 2018. They separated on November 1st, 2024. They've been separated for a few months now. They have 2 young kids together, ages 5 and 3. When they first separated, they started doing a 2-1 rotation. So my client would get 2 weekends, mom would get 1 weekend. My client would get 2 more weekends, mom would get 1 weekend. This is what they agreed to do before court action, before attorneys were involved, before emotions kind of went awry. The other non-disputed facts is I understand these parties lived in sort of a 3-block home, meaning they live right next to each other. One home on the left, middle, and then one on the right, for lack of better terms. The family, my client, his wife, and the kids lived in one, and then her mother, the maternal grandmother, lived on the third one on the far side. I'm not sure who lives in the middle, but regardless, that's the structure. They're all very close together. So oddly enough, when my client left the home and the marital community was over, he went and moved in with her mother. Her mother took him in. I think the biggest issue is you look at the timing. So Mr. McGee can comment about what a bad guy my client is or how he has no lack of motivation. It doesn't matter whether they want to see it. Bottom line is he's employed, has been for years. He works Monday through Friday from 6 a.m. to 2:30 p.m. He's had that job for a very long time. There's no issues. There's no allegations of issues of him maintaining employment. The reason I bring this up and why it's important is because there's claims now that somehow he's a drunk. I heard and or now there was an issue brought up in Mr. and maybe he responded to this. Maybe this was he misspoke of some sort. I didn't see it. He said December 24th. I didn't see any other incidents other than the December 8th incident. And so perhaps that's it. I didn't see any allegation of use and very little regarding any alcohol abuse of any kind. I don't believe my client has any criminal history. There's no alleged DUIs. There's no alleged police reports. In fact, it appears we only have 2 police reports, one from this incident and the one my client filed just recently. So I'll touch on that a little bit later, but it's a credibility issue. So I wrote down a couple of the things that, because I know Your Honor reviews the file, so I just want to highlight a couple of things. I don't want to regurgitate the declarations. I'll be relatively brief, but the credibility concerns. The first off that comes to my mind is the fact that we have an interpreter for mom today. As my client points out in his reply, and my client's pointed out since day one, mom doesn't, the declarations need to be translated for her. Mom signs all of these declarations without an interpreter. They're signed in English. They're typed in English. I don't know if she can do both, but I do know that she sat here today and told the court that she needed an interpreter because that is what she prefers. Hopefully that goes into the weighing of credibility when Your Honor decides this he said, she said stuff. Because the other thing is you look at these 3 declarations that were done in response. I recognize Mom didn't file those declarations or anything additional at the time she filed her initial protection order petition, but she filed these in response to the parenting plan. They are all strikingly similar in what they say, how they're written. It appears to be written by one individual, but again, we'll never know exactly what's happened, but there is no interpreter. So please take that into account. The other credibility issues that you have to look at that the parties can't change is the timing of everything. So why does mother agree to do a 2-1 rotation and agree to allow my client to have full weekends at a time for the first 2 months of their separation? Doesn't make any sense if he was truly this abusive individual. In fact, he continued to do visits, I believe, after this alleged December 8th situation. Why did Mom file this protection order 3 months after they were separated? Why file this is the most interesting when the case file came to me is why did she file the petition for a protection order only 2 days after my client filed for this solution proceeding? These parties were both pro se. My client took it upon himself to try to figure out how to file for the divorce, and he did so on January 6th of this year. 2 days later, Mom filed for the petition for protection order. Now, just because, in case we're wondering, she was served on January 6th as well. So this was 2 days. She filled out her petition for protection order and filed it 2 days after she was served with the divorce and realized her husband was in fact moving on. Another concern, why would he be allowed to live with her mother? Why does she continue to go to her work and his work and harass him? Mom is, I think she's a caregiver, a stay-at-home caregiver, maybe for her sister. I'm not sure. We don't get a lot of details about that. But what we do know is that my client's alleged she's been continuing since they've separated to go to his work where his girlfriend works as well and harasses both of them, trying to get them fired, making complaints. My client, that's where I said there was 2 police reports, one of which my client made a report on February 11th. He provides it. We summarize it in English, but he provided his statement in Spanish that Mom came to his work, and so he had to call the police to report it because of the temporary protection order's been in place the last couple months. He wanted to make sure he was doing nothing wrong when she keeps showing up to his work. Again, that's not behavior of someone that is truly scared, and these are violent issues. So talking about the December 8th alleged incident, we had some varying reports of that, which I'm sure Your Honor saw when, again, weighing the credibility. Interestingly enough, she came to him. This was 1 a.m. He's at her mom's house. She comes barging in because she finds out about the girlfriend and confronts him. But the most interesting that doesn't really weigh in her favor of credibility for accuracy is the cops, right? My client is one who contacted the police. It wasn't Mom. It wasn't Grandma. My client contacted the police. Mom's version in these 3 made-up declarations in response were that, well, Dad just went outside when the cops came and he dismissed him. He shooed him away. I've seen enough police reports in my lifetime. I'm sure Your Honor has as well, especially domestic violence phone calls. Police don't show up to the front step and be shooed away by one party. It just doesn't happen. They have to go make sure everything's okay. They have to speak to people. They have to see the inside of the home. They have to see children if they're involved. But according to Mom and these other witnesses, apparently Dad just told them go away and they went away. It's far-fetched. It doesn't make any sense. I think actions speak louder than words, especially with something like this. I know the first thing that comes to mind when we're talking about restraining orders, I recognize courts typically like to err on the side of caution. I recognize that's probably why it was signed initially on January 8th. We didn't have any information. And unfortunately, because of council's calendars, we just keep getting this continued to the point where we're at now, and it's been in place ever since. It's unfortunate for the circumstances, but this isn't a situation where it's fair to enter a protection order. It's where it's needed, where it's just desired by one party. We shouldn't hand them out like candy to little kids. It just shouldn't happen. This, as my client points out in his declaration, is very important to him. It has long-lasting effects. He's okay not being around her. We can have an exchange location at the police department if that makes everyone feel more comfortable. Mom can have her mother be the one that handles the exchange, or maybe her brother or sister-in-law. There's no need for these parties to have contact. But it doesn't mean that it's right to enter a protection order. He points out in his declaration how he has a citizenship review hearing. I'm not an immigration attorney. I'm not too familiar with that process, but he does have a review hearing in April. It's common sense to tells me if there's a protection order in place, that's probably going to have a negative impact on his review hearing, something that would be devastating to these kids to have their dad removed from their lives. It's a very serious issue. We're asking the court to weigh the credibility, deny the protection order. And as far as the parenting plan, we've really focused more on, which parent is making these truthful allegations about abuse. But you have to look at parenting functions, and there's nothing in here that addresses who can do what parenting functions, really, that my client is somehow unable to, or unable to rather. What he has shown, again, actions louder than words, is he had the kids for full weekends at a time before court started. So obviously he can handle that. My client is asking to enter a plan based upon what they've been doing, which is the 2-1 weekend rotation. He's not arguing that mom shouldn't be primary custodian. He agrees she should be. Obviously he's disappointed about her allegations and her behavior about girlfriend, but there's no reason to limit his visitation from weekends. Kids are fine. He's had them before. The mere fact that when Your Honor first continued this in January, I think it was January is the first time, or maybe it was Judge Giulotti. I think it was.
Hold on.
A little bit slower, please.
We're starting to outpace the interpreter just a smidgen.
Another reason Mr. Castillo does great, not a great fan of having the interpreters because it goes too slow. But I will try my best.
Are you ready to?
Yes, ma'am.
Okay, go ahead. Continue.
When Your Honor gave visitation with the pending hearing, it was without overnights, obviously less than what we were requesting. But my client had gone a few weeks, 5-6 weeks without seeing his kids. And you could see the tears coming to his eyes that he just got to see his kids again. Now, if that doesn't speak about a bond between a dad and his kids, I don't know what else does. He's not asking to be a primary custodian, but he undoubtedly loves these kids and wants to care for these kids. They are not in harm's way with that. Thank you, Ron.
Mr. McGee, any brief reply? And I've got some questions, but go ahead.
Salvador Lazo Curiel abandoned Aurora both times she was pregnant with each of their kids, Salvador Hector Lazo Castillo and Robert Ulysses Lazo Castillo. Salvador would just up and leave them, leaving behind family debt, not caring how his family would get by, and left a little money for Aurora and the children to survive on. Once Salvador checked out of the marriage for good, he checked out as a father, to the extent of not visiting them, not even calling, texting Aurora, or someone in contact with the kids to ask about them. I know Aurora had tried talking to him, trying to make him see things for the well-being of the kids, but his head just wasn't in the right mindset and he wouldn't listen. December 2024, my sister had called me hysterically crying, saying Salvador was hurting her and that the kids were there, and that he had said he was going to call the cops and have her arrested because he was angry that she would not fill out divorce custody papers in front of him. I was at work at the time. Your Honor, a bully. Got a bully. And is a bully. B-U-L-L-Y. And this 2-1 rotations never happened. Never.
What?
Ever. And anybody can go fill out a police report. That doesn't mean that it happened. And if you're worried about your path to citizenship, don't grab your wife by the hair and slide into the wall. That's a sure way to fall off the path to citizenship. And unfortunately, it has, if he's going to have those kind of impulse control problems, I'm not sure if I want him as a citizen. If it's not going to be my client, it's going to be the next girl, the next woman. So, he can go back if he's going to behave that way against women. So, that declaration I read to you was from Victor Castillo Garcia, which is, the kind of the 10,000 yard view person here, probably the least enmeshed. I mean, he's the brother, but he's kind of seen this go on, for a number of years. So And I don't know, there really isn't a denial by Mr. Curiel or his attorney that he did in fact my hair, push me. I was telling him to stop. He was me. He wouldn't stop.
Mr. McGee, wasn't there
I don't think
page 1 of the declaration? It says, I want it again to make it clear without question, I deny any of the abuse allegations in the protective order.
Okay, well, so he says it, but you got you got 4 people, okay, that are coming in from, all looking at a different facet of it, but they're all consistent. They're all consistent, and he says, oh, no, it just never happened. I mean, how do you get there? And these are people, some of them have been trying to help him with his problems. I mean, it's a pretty kind mother-in-law that lets the son-in-law who's chasing other women live with her so that he has a place to stay. I mean, these are people that have been trying to help this man with his problems. And then he goes and he behaves like this against not only my client, but the entire family. So these 2 people need a break from each other. We don't have Mr. Huberto knows a lot of people. He could have gotten a declaration from an AILA attorney that says, hey, if Mr. Salvador or if Mr. Curiel has a DVPO order placed against him for a year so he can cool off and learn to control himself, it will ruin his chances for the renewal of his green card, and he'll go back to Mexico, El Salvador, wherever. It's not there. It's just kind of this thing is kind of thrown out there. Oh, we don't want to do this because, he might have to leave the country. No, I mean, it's really pretty easy to get a declaration from an expert attorney from AILA. You call, open the phone book up. So, but it's just not there. So this whole thing, oh, we can't do this to him because he might have to leave. That is not a proper argument. So what is proper argument is that we have 4 people that witnessed and from different perspectives that were involved in this event. And then we have this it just never happened. It just never happened. It just doesn't stack up. So, what's it take, Your Honor? I mean, do I have to have a client with a broken arm? Do I have to have a client has a stroke from having her head on the wall? I mean, what does it take in this court to get a cooling off order, a nice DVP order for a year so he can just go over and work on his issues and learn to behave himself? And I don't think it takes, I don't think it takes a broken arm. That's kind of what Mr. Curiel is telling us. Well, if I hit her, it just never happened. I mean, it did happen. There's enough corroborating evidence of it. So at very minimum, the DVP order should be entered, and it should restrain him from a year from, the usual negative behaviors towards my client. And then, there is plenty of other evidence in here that he's doing this in front with the kids there. The kids around. His behaviors are involving the children. So I by extension, I just don't think he's ready to be in a good old dad parenting plan, because he's not. And now, I intend to move for GAL in this case. I think I'll be back on the 28th asking for that. If the GAL can do it, when at that time, Mr. Huberto and I can argue about what interim report, final report, all the typical subject issues. If the GAL comes back in 90 days or so and says, Mr. McGee, you're all wet. Your client says, I did some investigation and, this guy's great. then we can go, then we can do every other weekend, I suppose, because the jail's going to say, no, there's no problem with this. Your client's just making it all up. All these 4 relatives are all making it up. All 4 people are part of this. Never happened. But I don't think we're there yet. I think we're at a place where the kids need some protection. My client needs some protection, and it is only temporary. That's what I'd ask the court to do today. It's kind of curious, there's all this allegation about how hard of a worker he is and all this kind of stuff. I tried to get this all consolidated with I think I spoke when we were talking about this last time. We have a child support motion coming up. Let's just argue everything all at the same time. Parenting plan, child support, or at least I think that's what I argued. At least that was my intent. And, Mr. Huberto pushed this. Oh, no, we need a parenting plan. We need a parenting plan. We need a parenting plan now. And it's kind of interesting because I believe I did provide financials for my client and whatnot. He provided none. So if this guy really was this, hardworking, immigrant fella, Mr. Huberto and Mr. Garcia, have had kind of a prompting to produce that evidence, that shows, 80 hours every 2 weeks and, this time period, 100 hours, but, nothing's there. So I think that when we get the pay stubs, it's going to show something quite a bit different. And it's kind of curious that now I understand the pressure, to push, have this heard on Monday, as opposed to having it kicked over to a date when we can have all the financials to see if this guy's really who he claims he is, at least with respect to supporting. I mean, my understanding too is that my clients had to get diapers from he gives nothing, zero, not a zilch. He's this hardworking guy, but not a dime for his kids. She has to go get diapers from public assistance. So, I mean, talk about credibility, right? I mean, and you can't provide diapers for your kid. I mean, that is pathetic with a capital P. So, anyway, it's in the court's hands. I think my client wants me to add something. Oh yeah, and this whole thing about this showing up at his workplace, she's there picking up a W-2. He got caught. He has DVPO pending. So what's he do? He retaliates like, oh, she's harassing me at my workplace. Oh my gosh, I'm so threatened. She's there picking up a W-2 so she can file taxes. So I mean, come on, let's it's time for Mr. Curiel to grow up and be an adult. He says, oh, I want to be this great dad. Well, a bag of diapers would be a good start, wouldn't it, Mr. Huberto? Thank you.
Darren, can I make a couple brief comments? I know you had a question and I want to make it quick, I promise.
That's fine. I said, because you kind of are both moving parties, so
Yeah.
a couple times, then I got some questions. Go ahead, Mr. Huberto.
Okay. And by the way, if I will try to go slow, Mr. Castillo is not in my frame of view, so I forget he's there sometimes. I'll try to go slower, Mr. Castillo. There he is. My client has filed a declaration with this motion. Page 2 of that declaration, line 10 through 14. He says, I was initially giving her money for child support in November and December. I was paying her directly just about everything that I had. I reduced this amount last month because I couldn't afford to live any longer. So the allegations that he hasn't supported his kids is completely false. This wasn't denied by mom at all in her declaration. So Mr. McGee's argument of the contrary, quite frankly, shouldn't be considered at all. Likewise, my client sets forth on numerous occasions in the materials before the court that the court can legally consider that they have agreed to do a 2-1 rotation and that they in fact were doing a 2-1 rotation. The responsive declaration of mom doesn't deny this, doesn't address it one bit. Therefore, we have to, that's why I assumed it's to be the truth. Not only did my client say it under oath, under penalty of perjury, that it was interpreted to him. Mom doesn't deny it. As far as the domestic violence protection order as a separate petition, mom has to prove, it is her burden to prove that dad committed domestic violence. And as your honor pointed out, he denies it unequivocally. Absent that, I'm happy to answer your honor's questions, but I think the issues are pretty limited.
Yeah, I got a couple questions. First off, as the parties like to do, and so do the people that file declarations on each of their behalfs, they tend to conflate DV with parental functions. So they are separate issues. So, Mr. McGee, how does all of the declarations from your client's relatives, they basically equate him being a bad dad, and a lot of your argument is he's a bad dad, therefore he committed domestic violence. Now, I understand, and there's some statements in there that point out to, what I witnessed or what I saw, but a lot of it is, he's never around. He's a bad dad. He committed domestic violence. I mean, you can be a good dad and, as far as being there for the kids and taking time, and then you can still your partner, or you can also, not your partner and never be there with the kids. But a lot of your argument, it centers on, like, I don't care whether he bought diapers for the kid for purposes of the DV. The other stuff I get, that goes to other issues, but whether or not he committed domestic violence, and you tend to conflate the two, or at least in your argument, you're trying to get the court to go, oh, he's more likely to have committed DV because he's a bad dad, and look at all these declarations from these individuals. So is there any, and I'm not stating, there are some statements in there that they, that I saw so-and-so, I saw the dad with the mom. Okay, I'm not talking about that. It's the other 90% of the declaration and everything else. So as far as for purposes of DV, it's just whether or not he hit her or put her hair against the wall, stuff like that. So the other stuff doesn't matter for purposes of DV, correct?
Yeah,
Okay.
Clearly, but when I got to throw it all in one basket of an argument, yeah.
No, but it's, and I get that. Where's dad living now?
He moved in with a girlfriend.
Oh. When did he move out of grandma's house? And how come I don't have that information?
December 31st.
And Mr. McGee, why did your client wait a month to file the DVPO? And it is awful coincidence that she filed it the day after she was served with the divorce documents, and a month after the one incident that isn't just a he said, she said between the two of them.
Well, Your Honor, some families try to keep their matters private and don't just, run to the court with every little thing that happens. I mean, a lot of times, Hispanic families, they try to solve things internally, even things like domestic violence, and they don't always run to the police with every single thing, because that's, in some countries you don't want to be running to the police.
But why did she file the day after she was served?
Well, you know what?
I'm just asking.
Yeah,
I'm just kind of wondering. It's
When one, I mean, I think I'm providing an answer, and I'm blessed enough to be able to speak Spanish reasonably well, spend some time in the culture. Is that, once one person crosses the line and goes legal, then let's just have it all out. Okay, there's the line. There's the in the family, then there's the in the government and in the public eye, and what I've noticed in my representing this community that I feel very privileged and blessed to represent many members of, is that there's that dividing line. He wants to, there's even, and probably it comes.
So is that retaliation then? I mean, you're saying that since he
just like-
filed for divorce, she filed for DV?
No, you just, if we're going to be going to court, let's just have it all out in the courts. And unfortunately, I mean, I appreciate what New Hope does and some of these other agencies. And probably it would be, some of the people would be better advised to, okay, do a divorce action, or do a response to the divorce, and then file, a motion for your restraining order in the divorce. But they don't get that advice. Okay, they just don't get it at New Hope. They're just like, I appreciate what New Hope does. I appreciate the government's, the county's support of it, but they have a one-size-fits-all program. File a DVPO. Okay, so if she had come to me first, I would have said, oh, okay, let's file a response to the divorce, and then we're going to move for a restraining order. They don't get that education when they enter the system, if you will, from that avenue. So
What about the father brings up some of the inconsistencies in the relatives' declarations about who called the police, who was there when the police showed up? I do have conflicting declarations as far as some of them say so-and-so was here, before the police showed up. Others say so-and-so arrived after the police showed up. I did look at those and they are inconsistent, but they're not, I'm just,
yeah,
it's not like,
I
they're
don't-
using different people, but
yeah, I don't think those are particularly material. I mean, these are heated. I mean, you have a large man, a woman's and pulling her around by the hair. I mean, those are charged circumstances, and the
well, I'm bashing it. The one allegation, it says the mom she says, I had an unobstructed view, and Salvador jumped out of his bed, grabbed Aurora by her hair, and threw the wall.
Yeah.
Now, that doesn't say against the wall.
No.
It says he grabbed her by the hair and then the wall. Doesn't say that,
Well,
that's a little,
I don't know how it's not going to hit the wall when you get to the wall.
no, but I'm just
Yeah,
asking.
I mean, all presumably your entire upper torso is going to make, and some parts of your lower torso are going to hit the wall. So, but whether grandma was wearing a blue nightgown or a red nightgown when all heck broke loose, that's consistent with, that's the level of detail that, when did this relative show up or that relative show up? I mean, what is undeniable is that person after person is like, yeah, he did it. He grabbed the wall.
Mr. Mayor.
Yeah.
Documents.
No, it's all right.
The only, unless I'm wrong,
Yep.
the only one that actually saw anything was Grandma. Is that
Yeah,
right?
well, grandma was there. Yeah, correct.
Grandma was there, Grandma saw,
Yep.
Grandma wrote a declaration.
Yep.
All the other ones, they just kind of state after the fact what was going on, when the police called, who did what, but they didn't actually witness the
Well,
alleged incident,
I mean-
other than Grandma.
yeah. Your Honor, this doesn't, yeah.
I'm just asking.
Yeah.
Okay.
It's true. I mean, yeah, I mean,
That's fine. I
yeah.
understand. Mr. Huberto, what do I do with Grandma's declaration? I mean,
I don't think it's truthful. I don't, does grandma speak English? And clearly mom doesn't. And none of these are signed with an interpreter. I mean, that's the biggest struggle I have with these declarations. And I understand not being able to speak the language. I have empathy for that. That's why we have interpreters to make sure the parties understand. I painfully, and yes, it's extra time and effort, but I painfully have my client be every word interpreted to him. And that's why my staff signs that they interpreted it. So we know it's accurate. Because as counsel in these cases, Mr. McGee, myself, other counsel, we don't know. We can only represent what our clients tell us. Our clients are the ones who have to tell us, sign under penalty of perjury, what happens. So my client very clearly says what happens. And I think it weighs more credibility because of that.
Mr. McGee?
Sure.
I
Well,
guess that's,
Yeah, well, let's
I mean,
come.
what do
yeah.
I,
Let's come back on Friday, and I'll make sure that this new rule that Mr. Huberto is putting, that's not in the local rules, not in the court rules, not in any case or statute, is it's just his own rule that he wants to make up to try to derail this case. We'll come back on Friday, and I'll get declarations that these people have either speak English or wrote these things or whatever. But, if we start doing that on every single case, we're going to just, this court's already congested, and we're going to derail the whole court, because every time that, he said, oh yeah, I'm losing a case, I'm losing on some points, so I'm just going to pull out the interpreter card. I'm going to pull out the racist Hispanic card, and
I'm just, oh.
yeah, well, they have Hispanic names, so obviously they don't know what they signed.
Your Honor, clearly my clients object to that. I would never do such a thing.
Of course, Mr. Huberto was getting upset because I'm going to
My
the.
client's declaration says that he doesn't understand English. I got that from my client.
I'm her brother. I speak English.
He speaks just fine. What's wrong with his declaration?
nothing.
Yeah.
Does grandma speak English?
Yes, she does. She's a citizen of the U.S. So was my brother.
That's, I just,
Yeah. It's my client.
We've been helping her
Yeah.
at all times with the kids.
Your Honor, we need to have him stop talking. All right. Thank you.
So, yeah, so we'll just come back on Friday, and I'll get declarations from that just, yes, I'm a citizen, I speak English just fine, from grandma, from the mom. I'll get Mr. Victor's, well, of course, I already heard it, but I'll get him to sign something. And then just, we can bog down every family law case in this court for the next
Mr. McGee,
year until
stop.
Mr. Huberto wants to change
No,
this.
stop.
Okay. Okay. It's when somebody starts losing and they just make stuff up, just irritates me.
What are we talking about? Oh, shoot.
All right. So, Mr. Huberto, is there anything in the record that indicates grandma doesn't speak English or, hasn't had matters translated for her?
My client's reply declaration, page 2, lines 4 through 7, it refers to this. Ask the court to question it about understanding the English. Did she write it without any help? All
Nope.
of the declarations have the same format. They look like they were written by the same person. They don't have their stories straight. And then he highlights, as Your Honor did, the things that don't appear to be consistent.
I understand Aurora because she's using an interpreter. Mr. McGee, her stuff,
Well,
that's an issue.
Well, he's, yeah.
Stop.
Yeah, okay. Well,
As to grandma, so is there anything in there, Mr. Huberto, that says grandma's not? The grandma doesn't speak English? Not mom, but grandma.
nope.
I don't know if it specifically says grandma, Your Honor. It may not. It may just be the overarching credibility complaint about refers to it as being consistent or inconsistent with each other, but all three do appear to be written by the same person in English. So as to the points, the only two people on this one incident that's even alleged is mom, grandma, my client, and then the police. One thing we haven't been able to get yet, and maybe we need to, is the police report. I think it's kind of odd to think that the police wouldn't speak to these people if there's allegations of against walls.
Okay.
So the last thing I want to say, Your Honor, there's ways to solve everybody's problems without it being nuclear here. As indicated, my client doesn't want to be around mom. He's the one who wants to move on with his life. He alleges on a couple of occasions in his declaration that mom's been coming to his work and harassing him and girlfriend. We could have our proposed parenting plan has an exchange location. They don't need to talk to each other. They don't need to see each other. There's no reason for it. You don't need a restraining order. She's clearly not scared of him. She continues to come to his home. They did rotations with the kids even after they separated. And then they've been married for over 6 years. And she doesn't even allege any previous allegations of abuse. It just doesn't add up.
All right. So here's what the court's got. It's got, to a certain extent, two separate issues. We've got the DVPO and the parenting plan. On the DVPO, mom carries the burden. What I've got is I've got her statement that says she was assaulted by dad. I've got dad's statement that categorically denies that any of that stuff happened. I've got grandma's statement that she had an unobstructed view and saw him and throw her. Didn't say against wall or anything like that. It says it threw her. I said against the wall. I can't remember the exact language, but I have the police being called and being sent away. There's some concerns with that because I don't know what the police usually don't do that. However, I don't have any police reports. This is what the easiest thing, and I think the only thing the court can do right now is because they're separate issues, and I can bifurcate it and do that. So what I'm going to do is this. Both counsel indicated they want to get some additional information. Mr. McGee, I'll get something from the mom, the grandma, that says whether she speaks English or if not, whether that stuff was all translated for her or not. I want to know if those are her words, or if she understands what she was signing. And if she does, she speaks English, no sweat. That's her declaration. I got it. Mr. Huberto, you want to get the report? You bring up some issues there. I would like to know what's happened. I don't know too many cops that 911's called for domestic violence and they just leave, when people show up. So, sir, you'll be removed from the courtroom if you can't. Okay. All right. So I'm going to continue that case out and I'll find out from counsel what they want, whether they want a couple weeks or something. So, because it's a relatively close call. I've got mom stating that, he attacked her. I've got grandma stating unobstructed view and he threw her. Now that's different than all the stuff that mom says. It's just but it's corroboration, but I need to know, does she know what she's actually signing and saying? And I don't know what's going on with the police report. It'd be nice to have that information before I make a call because I've got dad categorically denying it and dad living in grandma, maternal mom's house. That's a little different. But I want to know if what grandma says is what grandma says. So, and both counsel, I think, say that. And it can, that can be separate and find out what is going on. As to the parenting plan, it's undisputed that mom's going to be the custodian. So I'll place the kids with mom. Right now, the court had, it was like daytime only, correct, Mr. Huberdeau?
That's what you did on the continuance, correct?
And what were the,
I'm trying to look for, I think it was just orally and it wasn't done. Was it done in an order? You might have hand wrote one on a continuance order. I don't have a copy of it, it would appear.
yeah, it's in the reissuance. It says 9 to 7, on on Saturdays and Sundays, every other week.
Oh, on the protection order case, yes.
An order case. So I don't know if we keep, I think the original one said it can be revisited. Yes, be revisited at the family law case. So this is what the court will do. Continue the protection order. How long do you guys want? 2 weeks, 3 weeks? What do you
I don't know how long it's going to take to get the police reports. I would say at least a couple weeks to get the police reports.
Mr. McGee?
Well, I would, the current can stay in place, right? The emergency one?
Yes.
Yeah,
As
yeah.
far as relating between them.
Yeah.
I'll deal with the kids in the parenting plan and we'll deal with that, but.
I would be, okay.
You want 2 weeks, 3 weeks?
I'd probably go to the 4th just to give some time because these things can unfortunately take time. So,
Okay.
and I'd rather go to the 4th and not have to have it be continued again. And that gives Mr. Huberdeau plenty of time to get his police report.
Okay. Work for you, Mr. Huberdeau, the 4th? Or is that during?
I have the recording.
No, I'm
of
actually
the-
gone on the 4th. I was trying to figure, you're right. I think that's the weekend before spring break, but my calendar says gone. So we'll have to do the 28th.
That'd be fine.
Okay, weeks?
Yeah, the 28th is fine, Your
All
Honor.
right, perfect. We'll set it out to the 28th. I will continue the restraint between the parties as far as not going to each other's homes and any of that stuff. I'll remove the kids provision. I'll enter a temporary, an interim order. I'll reserve on the limiting factors because I don't know what the court's going to do with the DVPO. So I'll reserve on that. I'm not denying it and I'm not putting them in. I'm just going to reserve till I get the information that I'm missing and make a ruling on that. In the meantime, I'll just go every other weekend visitation with the dad placed with the mom. That'll keep them apart. Right now, they've been doing daytime only, just not an overnight. We'll just go from, for right now, every other weekend. So,
Standard Friday at 6 to Sunday at 6.
yep, 6 to 6.
Alcohol, no alcohol or intoxicants.
I will, Mr. Huberdeau, are you, your client?
I didn't even see the alcohol allegations, to be candid with you. I didn't know that was a concern. I haven't asked him if he drinks or doesn't drink.
It's in mom's declaration. She indicated that he's drank and stuff. I mean, it wasn't.
Oh, years ago, my position is it's not, I can't imagine he has a problem not drinking for the limited time he has with the kids. But I don't think there's a basis for it in the declarations. But we'll do whatever Your Honor says to make, as long as he gets to see his kids.
I'll put in the alcohol, neither parent consume alcohol 12 hours prior to or during the time they have the kids. Mr. Huberdeau, regardless of what, it is a close, like I said, it's a close call right now. I'm missing a little bit of information. Just to let the parties know, probably regardless of which way I come down on the actual DVPO, the court may very well order a domestic violence evaluation, even if I find that it is a close call and the mom doesn't carry her burden. I might end up ultimately ordering a DV evaluation. I'm not saying I'm going to right now. I'll wait till we hear it and I find out, I'm definitely going to order it if I enter a DVPO. Sorry, Mr. Castillo, I'm fast. Okay. But just to let the parties know, if you wanted to at least look at that, what that might entail. So, all right. So I'll reserve on the limiting factors until the 28th. And on the DV case, the court intends to enter right now, every other weekend, Friday to Friday plan.
Friday to Sunday.
At the police station, or Friday to Friday, Friday to Sunday.
Yeah. Okay.
We'll take Friday to Friday.
Friday to Sunday. Meet at the police station to exchange the kids. You can send someone known to the kids and place unless council comes up with some.
We're doing Moses Lake Police Station. Is that what we said?
Don't you guys, Moses Lake? Both
Yeah,
of
I
you?
just had to double check for some reason that it was Moses Lake.
Obviously, the court doesn't have a vested interest in the transportation provision and location and who does it. If the parties in council arrive at some agreement that works better for them, that no problem, absent agreement, meet at the police station and you can each send somebody known to the kids instead of yourselves, grandma, grandpas, whatever. And like I said, the prohibition, about alcohol and reserving, like I said, on the limiting factors, and you guys can look at the DB evaluations, Mr. Huberto, if you want. I'm not ordering it right now, but I'm letting you know it's a close call, and depending on, even if I don't enter an order, I might, at DVPO, I may very well request an evaluation or require an evaluation. But anything that's left out or clarification, Mr. McGee?
No, I appreciate all the time that the court spent on this.
And whose weekend is coming up? Who had the kids this last weekend? I think it was mom. Because from what I had of the first and second or whatnot was going to be dads.
So this weekend would be dad's.
This coming up weekend would be dad's, Friday to Sunday, and then mom's the following week, and we'll have the hearing. Or if it gets continued again, it would just be every other weekend. So
We're doing unsupervised on this, unmonitored?
it wasn't supervised during with daytime only for the last few times. And like I said, most of the allegations aren't involving it's between mom and dad. And I understand if the court ultimately finds 191 factors, like I said, I may end up entering an evaluation and it'd be sole decision making, and we can revisit which way I come down if there needs to be monitored or supervised. But right now, there hasn't been any problems. I didn't see anything in the last two visits, or the last 2 weeks that were daytime only. So nothing was filed that indicates there was any issues or problems. And both parties filed additional declarations after that extension, after at least the dad's first weekend. That was time only for the Saturday and Sunday.
So do I understand Your Honor is going to handwrite a temporary order and a reissuance, or are we going to come back for presentation?
I think the easiest on the protection order, I will do a reissuance because I have one here. I will put in, so let's deal with this way we don't have to come back and nobody needs to spend more funds for interim temporary stuff. So the order was entered on 1/8/25 and is hereby continued through 3/28, right? 3/28/25 at 9 a.m. at Grant County Superior Court. I'm going to mark hearing. I'll come back to the other. Everyone was hearing. Protected person appeared in person, and the restrained person. Mr. Huberto, did your client appear by video, or is he here or not?
Yeah, he's in my office.
Okay, I'll put by video. And then counsel were here in person and by video. Counsel.
And you're I say my interpreter, but my assistant, who's my interpreter, is texting me while with my client's question. If he just agrees to do a domestic violence evaluation to put this at bed, does that move us forward without having to come back? I guess the concern would be he certainly doesn't want to agree to a protection order. But if he agrees to a domestic violence evaluation, can we be done?
No. Well, obviously, between now and the 28th, counsel is free to negotiate make whatever offers they want and can deal with anything. But unless Mr. McGee, unless you're willing to stipulate to that right now.
Well, I understood it was something Your Honor was contemplating. Is that was the moving of the needle for some reason was the DV eval.
Well, all I indicated and wanted to let the parties know was that what I said is it's a really close call. I've seen and I laid out why. I've got dad saying didn't happen. I've got the timing of this, the fact that dad lived with grandma, but I have grandma's statement that says unobstructed view. And now he didn't against the wall and all, and I realize each counsel kind of puts their client's best spin on it, but I've got a corroborating witness. Now it is mom's mom.
Yeah, I was going to say maternal grandmother.
I understand. By the same token, maternal grandma's letting dad stay in the house. I mean, and I don't have the police reports. It is a close.
I have the police report. I'm sorry.
Ma'am, just, you need to be muted. So all I was indicating is it's a close call for the reasons I said, and I'm missing a couple pieces of information. One of which is, does grandma, if she understands English, no sweat. I've got a clear declaration from her. I don't have the police report. We'll see what we have in a couple weeks. I was merely indicating that regardless of what the court finds whether it enters a DVPO or not, I may very well require a DV evaluation. I may not. I'll just hear from the parties, but if that helps the parties reach some form of a potential settlement, then great. But so
Thanks for the explanation, Your Honor.
so it's basis and more time. Agreement of the parties and to obtain more information. This does not have to be served because Mr. Huberto, you and your client are here.
Correct.
So service is not required. And then on the other, I will just, the children are removed from the protection order removed from this protection order extension as are included in the interim custody order. As per Judge Hill's temporary protection order that said it can be revisited in a family law matter. And then, so that takes care of this, but it does keep the protections in place. So dad can't go to mom's house, place of employment, any of those things. And I will enter a very simple and basic interim custody order. It will state until further order court, children placed with mom, dad to have every other weekend from 6 p.m. Friday to 6 p.m. Sunday. Dad's first weekend starts Friday, 3/14/2025. Exchange kids at Moses Lake Police Station. Either parent may send a designee known to the kids for transport. I think that's all that's needed for this order. I can put in here all other matters reserved. It basically, I'm not ordering 191 factors. I'm also not ordering them. It's just all reserved. Is there anything else that needs, this does give the parties, if you wish to kick stuff out a couple weeks, you've got something in place every other week, Friday to Sunday. If you start to negotiate and reach and need a little time, then it's not, is there anything else, Mr. McGee?
No.
That needs to be put in this interim order for right now, coupled with the DVPO that's being extended between the mom and the dad?
Is there anything? Hay algo más que necesitamos poner en el orden? Okay, I don't think so.
Mr. Huberto, anything else that needs to be addressed right now?
I don't think so. And Mr. McGee, since you're present, I assume you'll probably get a copy. Do you mind give me the courtesy of just emailing me a copy when you get back to your office? It might be quicker than I can get it off the court.
Yeah, I can't get it. The clerk's office is closed. It's 4:32. No. Oh,
I can
okay,
get
thanks.
you a copy.
Yeah, okay, thanks. I'll do that.
Okay.
Okay, thank you.
I'm just filling out, I put in the caption. I do want to, like I said, it's a close call. I know a lot of factors come into play, and I think when we get this other information, then, the court will go. And I already indicated a couple things that the court may or may not do down the road.
Yeah.
So anything else?
No, thank you for the special setting on this.
All right, I signed the order. All right, thanks. And
Thanks.
and the last thing is, if you guys agree on stuff like whether grandma, speaks English, I don't need a declaration. Mr. Huberto, if you and Mr. McGee agree, I understand, that there's arguments, but I don't need stuff if you guys agree.
Okay, thank you.
All right,
Thanks.
thanks. And I'll keep all of the documents.
I have so many questions. And like the first question I have is about the declarations. How can they be introduced, any of the declarations be introduced into the record without the person that wrote it being there? Because I always thought that was considered hearsay. So, because that person's not there to be cross-examined. I mean, her brother was there. He could have spoken if they were having a, quote, hearing or a trial where they would ask for witnesses. But I think, like moms or grandmas, they are thinking that maybe she didn't write it. Well, if she was in court, and maybe they should request her presence at the next hearing, if she was in court, she could answer that question. And if she needed an interpreter, then she didn't write it. Somebody else did. Which then asks the question, is that considered fraud? Or is the paper just ripped up, thrown away, and oh well? Or is there any repercussions over something like that? Because I don't really know. And then the hearsay thing, I don't know. Are the rules relaxed for a PPO in family court? I mean, I don't know. So that's a big question for me. It does sound like her applying for the PPO was somewhat retaliatory because of the timing. If you're truly afraid of this person, you would not be waiting a month and seeing him when he sees the kids or, whatever. But why wait a month if you're not, if you are afraid of him? I didn't really buy the explanation by her attorney that, they just don't want to, talk to the police. Okay, whatever. I didn't believe that. And then, the last thing, I could not believe my ears when I heard mom's attorney, in a roundabout way, called dad's attorney a racist because he questioned the validity of her declaration. He called him a racist. That I was shocked by that. That because the guy wants to find out if it's true and honest, you call him a racist. What's up with that? Anyway, I will put this on my calendar, the 28th, so that if it's up, I'll be able to grab it. So thank you guys so much for watching, and I'll see you next time.